Nnamdi Kanu, former lawyer and senior advocate of Nigeria, Mike Ozekhome, faces fraud charges by the Independent Corrupt Practices and Other Related Offences Commission, ICPC. When news broke that Chief Mike Ozekhome, one of Nigeria's most celebrated senior advocates, was facing criminal charges involving a London property, forged documents, and a dead general's estate, many Nigerians struggled to process what they were hearing. This isn't just another corruption case. This is a story that cuts to the very heart of trust in Nigeria's legal profession, and it raises uncomfortable questions about those we've elevated to the highest positions of legal practice. Let me walk you through this entire saga, because the details matter, and they paint a picture far more complex and troubling than the headlines suggest. Before we get into the charges, we need to understand exactly who we are talking about here. Chief Mike Ozekhome isn't just any lawyer. He is a senior advocate of Nigeria, which is the highest honor the Nigerian legal profession can bestow on a practicing lawyer. Think of it as the legal equivalent of knighthood. To become a SAN, you need to demonstrate exceptional skill, integrity, and contribution to the legal profession over many years. These are the people who argue the most important cases, who charge the highest fees, and who are supposed to represent the very best of what Nigerian law has to offer. Ozekhome, now 68 years old and living in the upscale Maitama district of Abuja, has built a reputation over decades as a fearless advocate, particularly in politically sensitive cases. He's represented opposition politicians, civil society activists, and controversial figures. His name carries weight in legal circles across Nigeria. When someone like this faces criminal charges, it sends shockwaves through the entire legal community. At the heart of this case is a house located at 79 Randall Avenue in the Brent area of northwest London. Now, London property disputes involving wealthy Nigerians are nothing new. For decades, Nigerian elites have been parking money in UK real estate, sometimes legitimately, sometimes not. But this particular property, purchased way back in 1993, has become the center of what might be the most elaborate deception case involving a senior Nigerian lawyer in recent memory. The house was registered under the name Talishani. That's where everything starts to unravel, because as it turns out, Talishani doesn't really exist, at least not in the way the property documents suggested. The story really begins to take shape with a legal battle that played out in the UK's first-tier tribunal, which handles property and land registration disputes. Between June 2024 and September 2025, this tribunal heard arguments about who really owned 79 Randall Avenue. The hearings took place over several sessions in June and July 2024, then again in July and September 2025, conducted via video link because of the international nature of the case. On one side, you had someone claiming to be Talishani applying for recognition as the property owner. On the other side, you had Chief Mike Ozekhome, initially represented by lawyers but later representing himself, claiming he had acquired the property from this Shani Tali person back in August 2021. And lurking in the background of all this was the estate of the late General Jeremiah Timbut Useni, a former Nigerian military officer and politician who had died in January 2025. Judge Iwan Patton presided over these hearings, and what he uncovered was nothing short of extraordinary. The tribunal didn't just rule on property ownership, it essentially exposed what appears to be a decades-long scheme involving false identities, fabricated documents, and attempts to obscure the true ownership of valuable London real estate.
To understand why this case matters so much, you need to know about General Jeremiah Useni. This wasn't just any retired military officer. Useni was a significant figure in Nigerian political and military history. He served as Minister of the Federal Capital Territory, meaning he once controlled Abuja's development and resources. He was also a senator and held various high-ranking military positions during Nigeria's years of military rule. Like many Nigerian elites of his generation, Useni accumulated considerable wealth, and like many of them, he appears to have moved some of that wealth offshore. The tribunal found evidence, including documentation from Jersey courts, that Useni had been using the false name Talishani to conceal offshore assets. Jersey, if you are not familiar, is one of those British Crown dependencies that has long been a favorite destination for people looking to hide money away from tax authorities and investigators. The tribunal determined that Useni was the actual purchaser of the London property back in 1993, and he registered it under this false identity to keep it hidden. This kind of thing was fairly common among wealthy Africans in the 1990s, when there was less scrutiny of international property purchases and offshore structures. Here's where the case gets truly bizarre. During the tribunal hearings, people showed up claiming to be Talishani. Not just one person, but apparently both a Miss Talishani and a Mr. Talishani appeared at different points. The tribunal concluded that both of these individuals were impostors. They weren't real people with legitimate claims to the property. They were actors in what the court determined was an elaborate deception. The Nigeria Police Force got involved in investigating these identities, and what they found confirmed the tribunal's suspicions. They checked national identification numbers and traced a mobile phone bill that had been submitted as evidence of Shani's existence. That phone bill led back to a solicitor in Lagos. Think about that for a moment. Someone went to the trouble of creating phone records and other documentation to make a fictional person appear real, and they got sloppy enough that investigators could trace it back to a specific lawyer in Lagos. This level of fabrication suggests serious planning and coordination. These weren't simple forgeries done in a rush. Someone put significant effort into creating and maintaining the illusion that Shani Tali was a real person. Chief Ozekhome's position throughout this case was that he had legitimately acquired the property from Shani Tali in August 2021. According to the charges now filed against him, he received this property while he was in London, supposedly as a gift or transfer from this Mr. Shani Tali. But there's a fundamental problem with this claim, which the UK tribunal identified and which now forms the basis of the Nigerian criminal charges. If Shani Tali isn't a real person, if the identities presented were fabricated, then how exactly did Ozekhome acquire property from someone who doesn't exist? And more troubling still, the prosecution alleges that Ozekhome himself was involved in creating the very documents that were meant to prove Shani Tali's existence. This is perhaps the most damning allegation in the entire case. Count 2 of the criminal charges against Ozekhome alleges that he created a false Nigerian passport. The passport number is A0753563, and it bears the name Mr. Shani Tali. According to prosecutors, Ozekhome made this document in Abuja around August 2021, and he did so with the specific intention of using it to support his claim of ownership over the London property. Think about what this means. A senior advocate of Nigeria, an officer of the court, someone who has sworn to uphold the law and maintain the highest ethical standards, allegedly forged a Nigerian passport. Not just any document, but a passport, which is one of the most serious identity documents a country issues. This isn't a case of signing someone else's name on a contract or backdating a letter. This is allegedly creating an entirely false government document. The Nigerian Immigration Service has been brought into this investigation.
They are listed as witnesses who will testify about the verification process they conducted on this passport. When ICPC investigators sent them the passport details, immigration officials examined it and determined its authenticity, or rather, its lack of authenticity.
A representative from immigration will explain to the court exactly how they verified the passport, what their findings were, and what those findings mean for the case. The federal government, through the Independent Corrupt Practices and Other Related Offences Commission, has charged Ozekhome with 3 distinct offences, and it's worth understanding each one clearly, because together they tell the story of what prosecutors believe happened. The first count relates to receiving property abroad. The law says that if you receive property outside Nigeria under circumstances that would constitute a crime if it happened in Nigeria, you can be prosecuted for it. The allegation here is that in August 2021, while Ozekhome was in London, he received this property at 79 Randall Avenue from the purported Shani Tali, knowing or having reason to know that something wasn't right about the transaction. This falls under the Corrupt Practices and Other Related Offences Act of 2000, which gives Nigerian authorities power to prosecute certain crimes committed by Nigerians abroad. The second count is about the actual creation of the false document. Prosecutors say that around the same time, while in Abuja, Ozekhome made that Nigerian passport bearing Shani Tali's name. The charge specifies that he intended to use this document to support his ownership claim over the London property. This violates the penal code that applies in the Federal Capital Territory, specifically the sections dealing with forgery and making false documents. The third count deals with fraudulent use of that false document. It's one thing to make a fake document. It's another thing entirely to actually use it, to present it to authorities or in legal proceedings as if it were genuine. The prosecution alleges that Ozekhome dishonestly used this falsified passport to substantiate his claim to the London property, even though he had reason to believe the document was false. This charge also falls under the FCT Penal Code. What makes these charges particularly serious is that they're not just alleging one mistake or one moment of poor judgment.
They describe a pattern of conduct: creating the document, then using it in international legal proceedings to try to secure ownership of valuable property. If proven, this would show deliberate, calculated fraud carried out over an extended period. The Independent Corrupt Practices Commission didn't just wake up one day and decide to charge a senior advocate with these crimes. Their investigation followed proper procedures, and the proof of evidence filed in court lays out exactly how they built their case. It started with a petition. After the UK tribunal delivered its judgment in September 2025, someone filed a formal complaint with the ICPC based on what that judgment revealed. The ICPC chairman assigned the case to investigators Mr. Joshua Wakili Musa and Mr. Tosin Olayiwola, who developed an investigation strategy that the chairman approved. These investigators then did what you'd expect in a serious fraud investigation. They sent letters to banks requesting financial records. They contacted government agencies for relevant documents. They reached out to private institutions that might have information. They obtained a certified true copy of the UK tribunal judgment so they'd have the official record of what the British court found. They recorded extrajudicial statements, which means they formally interviewed Ozekhome and other people connected to the case, documenting everything they said. On January 12, 2026, just days before the charges were filed, investigators took a statement from Ozekhome himself. That statement is now listed as one of the prosecution's exhibits. We don't know what Ozekhome told them during that interview, but whatever he said is now part of the evidence that will be presented in court.
The prosecution has lined up an impressive array of witnesses and documentary evidence.
They've formally listed 6 categories of witnesses, starting with the 2 main ICPC investigators, Wakili and Olaiwola, who will walk the court through every step of their investigation. They'll explain how they received the petition, how they developed their investigation plan, what letters they sent to various institutions, what responses they got back, and how all of this led them to conclude that charges were warranted. 2 other ICPC officials, Ebenezer Ndu and Blessing Manopo, are also listed. They are likely testify about specific aspects of the investigation or about ICPC procedures and protocols. The Immigration Service representative will be crucial. This person will explain their role, their authority to testify, exactly how they verified the Shani Tali passport, what they found, and what documents they generated during that verification process. The prosecution has also left the door open to call additional witnesses if they discover more relevant testimony as the case develops. As for documentary evidence, the list is extensive. The UK tribunal judgment from September 11, 2025 is obviously central because it's what triggered this entire investigation. Ozekhome's statement from January 12, 2026 will be important for what it reveals about his explanation of events. There are also documents related to interim forfeiture proceedings in the Federal High Court in Nigeria concerning this same London property, suggesting there may be parallel civil proceedings trying to seize the asset. There's a mysterious letter dated December 18, 2025, whose contents weren't disclosed in the court filing. We'll have to wait for trial to learn what that letter says and why it matters. The data page of the Shani Tali passport is listed, which makes sense since that's the document at the heart of the forgery charge. And the prosecution has reserved the right to introduce any additional documents they obtain before or during trial. This case didn't emerge in a vacuum. Back in October 2025, during a special court session marking the beginning of the Supreme Court's legal year and the inauguration of 57 new senior advocates, Attorney General Lateef Fagbemi, who himself is a son, delivered remarks that now seem prophetic. Fagbemi didn't mince words. He talked about the rot in Nigeria's judiciary. He revealed that his office had been receiving numerous complaints against senior lawyers, complaints serious enough to suggest professional misconduct. He specifically mentioned the UK judgment involving Ozekhome and General Useni's estate, making it clear that his office was looking into the matter. The Attorney General announced that his office was taking the unusual step of verifying the authenticity of these complaints with a view to referring them to appropriate disciplinary bodies. He called for cooperation from the Nigerian Bar Association and the body of senior advocates in cleaning up the profession. At the time, many people might have dismissed this as just tough talk, the kind of warning that politicians issue but don't necessarily follow through on. But now, just a few months later, we're seeing that Fagbemi meant business. The federal government, through the ICPC, has actually filed criminal charges against one of the country's most prominent SANs. The implications of this case extend far beyond one lawyer's fate. Nigeria's legal profession operates on a foundation of trust. When you walk into a courtroom, everyone, from the judge to the opposing counsel to the court clerks, assumes that lawyers, especially senior advocates, are operating with integrity. They assume that documents presented are genuine, that representations made to the court are truthful, and that these legal practitioners understand their obligations to the justice system. If the allegations against Ozekhome are proven, it shatters that assumption. It raises questions about how many other cases might involve similar deceptions. It makes judges and tribunal members wonder whether they should be more skeptical of documents and claims presented by even the most senior lawyers. The Nigerian Bar Association will be watching this case closely because it has implications for how they regulate their members. The body of senior advocates will be equally concerned because the SAN rank is supposed to mean something. It's supposed to signify not just legal skill, but also unimpeachable character and professional conduct. There's also a broader question about wealthy Nigerians and offshore assets. The Useni case reveals what many have long suspected, that senior government officials and military officers have been moving money out of Nigeria and hiding it through complex offshore structures and false identities. If someone as prominent as Ozekhome could allegedly be involved in such a scheme, it suggests these practices might be more widespread than we realize. As of now, the High Court of the Federal Capital Territory hasn't announced a hearing date for these charges. That will come in due course as the court's calendar allows and as both sides prepare their cases. Ozekhome, being an experienced litigator, will undoubtedly mount a vigorous defense. He knows courtroom procedure better than most. He understands evidence rules, witness examination, and legal argument at the highest level. This won't be a case where the defendant is intimidated by the legal process or unsure how to defend himself. The prosecution, led by Dr. Osuobeni Ekoi Akponin Singha from ICPC's high-profile prosecution department, also appears to have prepared thoroughly. The detailed proof of evidence they filed suggests they've built their case carefully, gathering documentary evidence and lining up witnesses who can testify to specific facts. One thing working in the prosecution's favor is that they have an independent foreign tribunal judgment that made findings of fact about this property and these documents. They are not starting from scratch. They have a detailed British court ruling that examined evidence, heard testimony including from General Useni himself before he died, and reached conclusions about who owned the property and whether the Shani identities were real. It's worth stepping back and thinking about what these charges really mean in the Nigerian context. Corruption cases against lawyers are relatively rare in Nigeria, and criminal cases against senior advocates are almost unheard of. The legal profession has traditionally policed itself through the Bar Association and disciplinary committees, with criminal prosecution reserved for only the most egregious cases. That the Attorney General's office decided to pursue criminal charges rather than just referring this to a disciplinary panel tells you how seriously they view the allegations. Forgery and fraud charges carry real prison time if there's a conviction. These aren't professional misconduct charges that might result in a suspension or disbarment. These are crimes that could send someone to jail. The Corrupt Practices Act charge is also significant because it shows the government using anti-corruption laws against a member of the legal elite. For years, anti-corruption efforts in Nigeria have focused on politicians and civil servants. Expanding that focus to include senior lawyers represents a shift in approach. Behind all the legal jargon and formal charges, there's a human story here that shouldn't be lost. General Useni is dead now, having passed away in January 2025. He can't defend himself or explain his actions. His estate is left dealing with the consequences of decisions he made decades ago when he allegedly set up this offshore structure using a false identity. Ozekhome, at 68, is facing the possibility of spending his final years defending himself in criminal court and potentially in prison if convicted. Whatever legacy he built over decades of legal practice is now overshadowed by these allegations. There are also family members involved,
people connected to Useni's estate who have been trying to recover what they believe is rightfully theirs. The legal fees alone in a case like this, spanning multiple jurisdictions and years of litigation, must be astronomical. As this case moves forward, there are questions that still need answering. If Ozekhome did create a false passport and use it in legal proceedings, who helped him? Forging a Nigerian passport isn't something you typically do alone. It would require knowledge of passport security features, access to materials, and potentially cooperation from people inside the immigration system or document production process. Why did Ozekhome, if the allegations are true, think he could get away with this? He is an experienced lawyer who knows that UK tribunals take evidence seriously and that false documents can be detected. What made him believe this scheme would work? What happened to the property itself? Is it still registered in the shiny name, or has it been transferred to Useni's estate following the tribunal ruling? Are there other properties or assets that might be connected to similar schemes? And perhaps most importantly, how widespread is this practice? Is this an isolated case of one lawyer making catastrophically poor decisions? Or is it indicative of a broader pattern of senior Nigerians using false identities and forged documents to hide offshore wealth? This case sits at the intersection of several major issues facing Nigeria today. There's the question of corruption and how far it reaches into institutions we expect to be above reproach. There's the matter of offshore wealth and how Nigerian elites move money out of the country and hide it from authorities. There's the issue of professional ethics and what happens when people in positions of trust violate that trust. It also touches on Nigeria's relationship with the United Kingdom, which has long been a favorite destination for Nigerian wealth, both legitimate and otherwise. The UK tribunal's willingness to dig deep into this case and expose what it found suggests British authorities are taking seriously their obligations to prevent their property market from being used to launder questionable funds. For ordinary Nigerians watching this case unfold, it's yet another reminder of the gap between the elite and everyone else. While most Nigerians struggle with Ozekhome's defense strategy will be analyzed by legal experts. If the prosecution can prove its case beyond reasonable doubt, it will represent a significant moment in Nigerian legal history. A senior advocate convicted of forgery and fraud would send a powerful message that no one is above the law, regardless of their professional standings or connections. If Ozekhome is acquitted, it will raise questions about whether the prosecution rushed to judgment or whether the evidence wasn't as strong as the charging document suggested. It might also prompt questions about whether this was a politically motivated prosecution, though there's no evidence of that at present. Either way, this case has already changed the conversation about legal ethics and accountability in Nigeria. It's reminded everyone that trust in the legal system depends on the integrity of those who practice law, and that when that integrity is called into question, the entire system suffers. The story of 79 Randall Avenue, London, a house purchased 3 decades ago under a false name, has evolved into a test of Nigeria's commitment to holding its elite accountable. Whatever the outcome, the case will be studied in law schools and debated in professional circles for years to come. And for Chief Mike Ozekhome, SAN, the coming months and possibly years will determine not just his freedom, but how history remembers him.